with that particular law from the initiation or from the understanding of that particular law? No. Once we start reading that particular law, start understanding the provisions of that particular law, and then only curiosity will be there to understand more about this particular law, and then you will be engrossed to this particular subject, which is known as Information Technology Act or cyber law. So don't get yourself confused when somebody speaks about cyber law, Information Technology Act, or IT related laws, etc. etc. This is the mother of all cyberspace related law, that is Information Technology Act 2000. This act was enacted in year 2000, and India was one of the originating countries which, based on UNCITRAL model, framed this particular Information Technology Act or rules and regulations in year 2000. At that
मैम मैं
time,
भेज रहा हूँ.
technology was at very nascent stage. It was not fully developed, but still some law to regulate this particular e-commerce activities and online activities were required. And at that point of time, this particular law was enacted.
मेरा रेडी है.
Then in 2008, there were few important changes in this particular law. And then what we see is Information Technology Act as amended in year 2008. So
मैम वो हमको है
previously
ना
it was
एक्चुअली
Information
आज वेबिनार
Technology
ज्वाइन करने
Act,
को बताया था
which
8
was
बजे
enacted in
8:45 को.
2000, subsequently
तो
amended in
यहाँ पर
2008.
कॉलेज में
Some
अभी
major
चालू है.
amendments were carried
चालू
out
है,
in
हाँ आया था कल,
2008,
अंकित सर का
and
आया था,
thereafter
अंकित श्रीपतवार
few
सर का
notifications, few guidelines have arose,
है. बाकी लोग
like
ज्वाइन कर लिए
deletion
हैं.
of section
हम, हाँ
66A, repealing of section
हाँ
66A by Shreya single judgment,
साइबर
and
लॉ पे
lot
है
of
मैम.
developments are happening. So
हाँ.
currently, what we must understand is there is a law which regulates technology or cyberspace, and that law is very crucial because each and every aspect of human being is now revolving around these particular technologies, and a small impact of technology. Tina ma'am, your mic is on. So a small impact on technology or impact of technology may change entire regimes, what we have seen in Nepal recently, Gen Z. So everything what is happening in this particular cyberspace is affecting our day-to-day life, and this is the significance of Information Technology Act. And I'm glad that at least you have taken some efforts to understand this particular law. The basic understanding about this particular law is three important definitions, that is what is computer, computer network, and computer system. So computer definition you can read in section 2, that is definition always there, section 2 of any act. So computer is any device which carries out important functions with arithmetic, logical, and memory functions. So, any device capable of performing these three activities, that is arithmetic, logical, and memory function, can be termed as computer. That is the importance of understanding computer. Then another definition is data. Data is consisting of all the information which is processed or in the raw form. Any content can become a data depending on circumstances, and with lot many captions you have read that data is new oil, data next war will be for data, and every company is running after gathering of data. So any information which can be attributed to an individual becomes a data, any small content. So for you, 1, 2, 3, 4 may not have any significance. This is random or sequential numbers. But 1, 2, 3, 4 can be somebody's password, can be somebody's OTP. So any form of information which is available in digitalized form becomes a data, and even when you go to Data Protection Act, which is the new offshoot of Information Technology Act, Digital Personal Data Protection Act 23, there even the information available in physical form, which can be converted into digital form, is also considered as a data. So another definition is there are three important sets, that is the intermediary, service provider. So any information or any data from computer is transmitted from one person to another through some network, through some connectivity, that all factors which help in transmission of data are collectively known as intermediary. Those are the facilitators of this particular communication from one end to another. So all those facilitators like your service providers, search engines, some websites, all those can be termed as intermediaries because they facilitate in transmitting data from one location to another. Now, I'll just close my mic to have greater connectivity. So, another important thing you must understand as far as understanding of cyber law is concerned, every law has some civil aspect and some criminal aspect. So, Information Technology Act 2000 is a mix of both. Few provisions under Information Technology Act revolves around civil litigation and few provisions revolve around criminal litigations. Like if you have studied IPR laws, few provisions there are civil, say, compensations can be claimed, few provisions where police complaint and FIRs can be lodged. So similarly in Information Technology Act, these provisions are there. So section, if we go by section to section, section 1 speaks about the title is Information Technology Act, which is applicable in entire India. Now, at that, please mute yourself. Somebody's mic is on. Please mute it. So, even in 2000, Information Technology Act was directly applicable in state of J&K. Now, everybody knows what is the fate of state of J&K. But at that time also, it was understood what was the magnitude of this particular act, and it was made directly enforceable in state of J&K. That is what is section 1 is all about. Section 2 is broadly, as I addressed, definition part, where we have gone through definition of computer network and computer system, intermediary, service provider, then addressee and
मैम आपका माइक
recipient. So to whom you originate
हाँ वो
commission
माइक से म्यूट की बटन होती है हाँ
is
वो कर दे
known as addressee, intended recipient of that particular communication, then originator of that particular communication, then we have seen definition of what is communication. So, and data. So these are the important provisions of Information Technology Act as far as definition parts are concerned. Then section 3 to 42 entirely revolves about one particular mechanism which is known as digital signature. As need was there at initiation of Information Technology Act, that what could be the legal recognition of the communication carried out by Information Technology Act related content. So to give authenticity or to give legality to this particular communication, which was carried out with the means of information technology or with the help of digitalized medium, one mechanism was devised to authenticate that particular communication, that is known as digital signature. So digital signature is that particular form of technology which makes data entirely non modifiable. Non modifiable in the sense, Most of you, I presume, understand technology. So, what we understand about technology is that when we create one word file and send that particular word file to another person, that word file can be modified. Even people have technologies. Yes, somebody has question. Naneshwar, do you have any question? Please ask. Okay. So, as we know that technology is easily modified to prevent that misuse of technology or communication. This mechanism was devised which is known as digital signature. So one important evolvement or important development at that point of time, that digital signature was created. So section 3 to 42 mostly revolves around digital signature. Prior to that, how message can be delivered, etc., are the provisions. The legal provisions, uh, I don't understand what you intend by BSA. Can you elaborate? Somebody has put one message, that is BSA. What is meant by BSA? Please explain.
Sir, Bharatiya Sakshi Adhiniyam, when we present an electronic evidence, it's
Yes.
a hash we can give.
So that
Actually, we
is
have to give,
how,
it's mandatory.
yes, that is how this signature works. It is based on hash technology only. The broadly understanding of digital signature is that your message, whatever is the content you want to sign, that message is encrypted. When some name is applied, key is applied on that particular message, that message becomes encrypted. Now that message is transferred to recipient. After reaching that message to recipient, public key means corresponding public key of your private key is applied, and that message is again brought back to its original form, means decrypted. So encryption and decryption are two words. Now with the WhatsApp's understanding of everyone, that messages are end to end encrypted, so nobody can intercept those particular messages if you carry out communication through WhatsApp. That is what is use of digital signature. So when you put digital signature, what function happens at the back end is your message gets encrypted. It is traveling now that particular message through unsecured mode of communication. It reaches to intended recipient. Intended recipient opens or decrypts that particular message by applying public key. So these concepts of what is private key, what is public key, is something will require huge amount of time. So in short, you must understand that simple mechanism is your message is logged from your end by a key available with you. Now that message is dispatched, that message is received by intended recipient. He has that particular key which corresponds to your own key. Or for that, those who are aware about locker mechanism of bank, that there is one master key available with the banker which can only open that particular locker, but that key is not capable of closing that particular locker, and the key available with you is the only key which is capable of closing that particular locker. Similar technology is used for this particular, and what the previously gentleman referred as a hash function is, that is hash functions are matched when at the both end, when you apply the key and when recipient uses that particular key to open that particular message, if both the hash matches, then only message gets opened. So this is digital signature, but this field is not yet developed fully. So I am skipping this particular portion of up to section 42 of digital signatures because it needs huge amount of time to explain how this. Only thing you must understand is there are two key players in this particular mechanism of digital signature. One is sender, another is recipient. The sender has to obtain digital signature for himself. That digital signature has two elements. One is private key, another is public key. Public key is available for everyone to use that. By private key, messages are locked. By public key, messages are opened. And one hash function is there which creates date and time stamp. So when message was locked and message was unlocked. And what Indian Evidence Act says, all the communications carried out with the use of these particular signatures or such signatures are authenticated messages. Then section 43 speaks about civil liabilities. 43 with criminal intent becomes section 66, which is criminal part of it. So section 43 is if any person without the permission of owner access a, then there are 10 different provisions, does following activities, then he is liable for compensation. That is section 43 is all about. So main ingredients of section 43 is any person without permission of owner or in charge of that particular system. So if anybody without owner or in charge of that system's permission does any activity with computer, computer network or computer system, then he will be liable to be punished, or in civil sense he will be liable to compensate the person whose system he has accessed, manipulated, etc., etc. So, section 43 contains maximum, say, illegal activities which can happen through computer. So, we will go one by one because there are 10 subsections in section 43. A is access, illegal access to that particular system. So, access means touching that particular system, doing some, trying to enter into that particular system, even attempt to guess somebody's password can be termed as trying to gain illegal access. Even if you are trying to open somebody's lock pattern on mobile screen, that will be termed as trying to illegally access that particular mobile phone. So only section 43 subsection A access has maximum illegal activities covered within it. So section 43 subsection A speaks about accesses, B speaks about copies, downloads or extracts. So as everybody knows, whatever is available on internet is free to use, with this understanding that if you record anything without permission of owner, it is prohibited activity. Now, on one side, everybody understands that whatever is available on internet is free to use, without permission of authority. Owner, then he is liable for certain damages. So, section 43 subsection B makes it very clear that whatever we see on internet or computer or on mobile phone is somebody's copyrighted content. So simultaneously with the understanding of Information Technology Act, you must have sound understanding of copyrights, because now you see somebody using somebody's name, creating some fake profile, all these are punishable activities. So copying, or even if we are downloading some content available on computer on some website and using it for some different commercial purpose, then that is also prohibited activity. So again, section copies, downloads or extracts has huge or wide meaning that we must understand. Then section subsection C's introduces or causes to be introduced any computer contaminant or computer virus into any system is prohibited act under section 43 subsection C speaks about deletion or destruction of any computer system damaging the system that can be physical or virtual damage. Then disruption or causing disruption, even if you break somebody's internet cable or if you shut down somebody's internet, that can be termed as disruption of any computer system of computer network, and the creator of that particular system can be penalized. Then denies or causes denial of access, like somebody's password you have changed, that is denial of access where he is authorized to access. So there could be various example of denial of access. Some server room is there and somebody has closed or locked that particular server room, that is also denial of access to those particular system. So this could be practical life example. Then as in any law providing any assistance to this sort of illegal activities, then charges the services availed of by one person on account of one person to account of another, that is time theft. When we go and use free wi-fi or free connectivity, then we are utilizing somebody's services for which some other person is paying, but we are enjoying those particular services. That is also prohibited if all these activities are without permission. So keep it in mind when section 43 is there, if any person without permission of owner or in charge of that particular system does these 10 activities, so that is very crucial to understand. So when you join this particular profession, just try to understand how this section is applicable. Information Technology Act section 43 is specifically applicable when that act is made without the permission of owner or in charge of that particular system. So when it comes to legal point, what you understand in book is one thing, theory is one part, practical is one part. How these sections are really applied in industry or in real life is real challenges, because by mere going to definition part or accesses any system, but you have to find out where that particular access was illegal or exceeding authorized access, whether exceeding authorized access becomes illegal or not. So example of exceeding authorized access is like in most of the companies, you are allowed to visit up to some, say, guest room or some frontage area. Beyond that, you are not permitted to enter. There it is mentioned, permission restricted. So at the reception, permission is not required, that access is illegal, but where permission is prohibited or specific permission is required and you try to enter into that particular area, it becomes exceeding authorized access. Your authorized access is up to this area. Many times you find it is mentioned restricted area. So access to that particular area is prohibited. So when you understand this particular law in depth, you will come to know what are the specific functions and how those can be exploited. So section 43, very crucial section, because all what is there in section 43, if those are done with malified or criminal intention, it becomes section 66. When first and very important information, because most of you may not be having bare act with you of Information Technology Act, my sincere request or advice is to purchase Information Technology bare act with very recent updations, because there are different versions available of Information Technology Act on Google itself. where it will show only section 43 and section 65, 66, 67 in Information Technology Act. That was in old version 2000, where only seven provisions were there in section 43, subsection A, B, C, D, E, F. Then in 43A was not there. Section 66 you will find only under criminal provisions you will find only section 65, 66, 67, whereas those have been amended. So please have bare act of Information Technology Act 2000 with recent version, so that all the subsequent notifications amendments would be there. So try to understand Information Technology Act with having bare act with you. Section 43 with 10 subsections, and the compensation is proportionate to damage, means there is no upper limit. So what is your understanding? What is the maximum limit you have understood? Tina has raised hand. Please go ahead if you have any question. Yes, anyone has any query up till now?
Sir, I would like to understand, is there any like a time limitation from the date of knowledge if a person suffers, say, from an act of hacking,
No, no. This is now limitation. What you are talking about is limitation.
right?
Normally, it is a big topic of limitation. Always defense is, I realized at this point of time and I came to this particular code. That is how limitation. It is always better to report that particular matter as soon as possible, as and when you noticed. But it may happen that you will feel that particular activity may not be suspicious. You may think some malfunctioning is going on, etc. So the when the real or actual knowledge of that particular illegal activity comes to your notice, immediately you must report. Normally in civil litigation 2 years limitation period is there. So different laws have or different acts have provided specific limitation period. So you must follow that particular limitation period. But normally 2 years is the limitation period for civil suits. So you must file that particular complaint within 2 years of knowledge of that particular incident. Many a times it may happen that opponent will try to prove that you had knowledge of this particular activity 10 years ago and now you have come before this particular court. So you are barred by limitation, etc., etc. So the always sincere advice will be to initiate your remedies as soon as possible when it is in your notice. That is how I address your question. Yes, Mr. Raj has some question. Do you have any question, Mr. Raj? No. Okay. So, section 43 with 10 sections, higher ceiling is not prescribed. What compensation you can claim? So, you can claim any compensation, but you must be able to establish. You can ask for 1000 rupees, 10,000 rupees, 1 crore rupees, 10 crore rupees compensation for that particular illegal access, because if somebody's thesis is say washed out due to some introduction of computer, how you will evaluate that particular data, and evaluation of data is very crucial. So upper ceiling is not prescribed under Information Technology Act. Any compensation can be claimed, only it depends upon the damages, how you can establish or prove that particular damage. Now if you read Information Technology Act currently, you will find section 43A, compensation for failure to protect data. Now with introduction of Digital Personal Data Protection Act in 23, this provision is repealed. It is no more in existence in Information Technology Act. But I recommend each and everyone to go through that particular provision, because that is of huge magnitude. Section 43A, compensation for failure to protect data. If your data is available with some service provider, intermediary, or anyone, and if he fails to protect that particular data, due to which if you suffer certain loss, you can claim compensation. That is the gist of section 43A. As of now, with the introduction of Digital Personal Data Protection Act, how many of you have at least knowledge of that this particular new act, which is known as Digital Personal Data Protection Act, is passed by the Parliament and is in public domain? How many of you are aware? Please raise your hands. I don't see any hand raised still. Yes, one hand is there. Anyone else other than Chirag? So this is most recent law in Data Protection Act in information technology domain, which will be required to be studied by all of you. So simultaneously go through Digital Personal Data Protection Act, just have gist of it, understand what that particular law is, because entire section 43A is repealed by the introduction of that particular law. That is the magnitude of section 43A. Then there are provisions of adjudicating officer before whom the civil matters can be taken up. All civil courts are barred from entertaining the matter under Information Technology Act. Civil matters. Normal civil suit cannot be initiated in normal civil courts. What you find at every district level or taluka level, special officer is designated, which is known as adjudicating officer. That adjudicating officer is information technology of respective state. So all the states in India has only one adjudicating officer to adjudicate the matters covered under Information Technology Act. This is the magnitude of this particular act. For entire Maharashtra, only one adjudicating officer is appointed, who is IT Secretary, Information Technology Secretary, State of Maharashtra. So he is the person to whom the matters are filed, before whom matters are filed. He decides on that particular matter. Those provisions are available in section 46, provision for adjudicating officer. Then appellate authorities are there. That is, previously it was cyber appellate tribunals. Now that cyber appellate tribunal is merged into TDSAT, Telecom Dispute Settlement Appellate Tribunal, TDSAT, which is at New Delhi. So you broadly understand first level of appeal, or not appeal, your complaint goes to adjudicating officer who sits at Mumbai. Appeal of the judgment or decision of adjudicating officer is brought before Telecom Dispute Settlement Appellate Tribunal, that is Appellate Tribunal, which is located at Delhi. And then the matter moves to High Court and Supreme Court. These are the stages. First is adjudicating officer, second is TDSAT, third is respective High Court, fourth is Supreme Court. So this is the hierarchy or legal judicial hierarchy, how which through which these matters travel. Then we come to sections 65, 66, 67, which are criminal parts or criminal provisions under Information Technology Act. Section
Hello.
65 speaks about
हाँ
source
सर.
code related offenses. As most of you may be knowing that all the computer programs revolve around certain secret or certain, you can say, basic ingredient, which is known as source code. All programs are written by software developers through some source codes, through some commands, set of commands. All those collective set of commands is known as source code, and tampering with that particular source code is a huge offense, and which is punishable for 3 years of imprisonment. So section 65 speaks about source code theft or crimes or manipulations related with source code. That is section 65, for which 3 years jail term is prescribed. Then section 66 That is, as I previously explained, all what is in section 65 with malified intention becomes section 66 in criminal liabilities. So, if any person dishonestly or fraudulently does any act which is referred in section 43, that is accessing, copying, downloading, damaging system, disruption, denying information, as abetting or assisting any person, all these 10 provisions, if those are carried out with dishonest or fraudulent intention, it becomes punishable under section 66. So, simultaneously for illegal access, there could be civil damages, there could be criminal provisions under section 66, civil compensation under section 43, criminal provisions under section 63. Same act, it can be colored as civil as well as criminal. So, the punishment again in section 66 is 3 years of imprisonment and fine which may extend to 5 lakhs rupees. Why I refer to go through new or amended provisions? Previously, section 66 was different. Word hacking was used. Now, this is computer related offense. Previously, it was understood that it was hacking. Hacking is illegal access, gaining illegal access to any system. That is the legal understanding of hacking. So, you must read 43 which amended in 2008. Those all provisions are now section 66. Then section 66A, punishment for sending offensive messages through communication devices. Again, this 66A is now repealed by the Shreya Singhal judgment. You may be aware, but those who are interested can go through provisions of 66A because it is very crucial section to understand Information Technology Act, or as well as what activities are prohibited under Information Technology Act. Then section 66B, punishment for dishonestly receiving stolen computer resources. So all these official chor bazaars like online marketing stores, whenever you purchase or procure things from those particular stores, be aware, because section 66B specifically says punishment for dishonestly receiving stolen or communication devices. So whatever things which are put on these particular platforms for sale may not be official things. Somebody may be stealing somebody's laptop and selling through online marketplace. So you have no means to verify from whom you have purchased that particular gadget or device. So always be cautious when you procure this thing. Always have some official receipt, some documentary evidence with you. You have procured from these things from so and so platform, etc. Because here recipient will be termed and he will be tried before court, because section wording of section 66B is such: receiving communication devices. Section 66C and D are identity theft and personation. Like I have explained previously, that putting somebody's fake profile or creating somebody's profile and you are using it, putting somebody's fake poster, photograph, etc. So identity theft and personation, pretending to be someone else. So these are common offenses which are happening through this particular platform. 66C and D are normally simultaneously used when criminal sections are imposed, and those are again are punishable up to 3 years of imprisonment and fine is prescribed. Then section 66E is offending somebody's privacy. That is, like you have understood, putting spy cameras in somebody's room without his knowledge or her knowledge. These are using somebody's information. Recently there was horrible thing that some conversations were leaked recently, two or I think few days ago. Some doctor's operation was means that particular camera was hijacked or hacked, and all the activities were displayed to public. So these sort of publishing of obscenity or capturing of this privacy are punishable under section 66E. Again, 3 years imprisonment. Section 66F, cyber terrorism, under which severest of punishment is life imprisonment, which can be imposed through section 66F. Recently, one of the person was convicted under section 66F. The crime happened in Nagpur. The person was working with ISRO. He shared some information to some Pakistani spy. So, section 66F revolves around cyber terrorism. Then comes section 67, 67, 67A and 67B are all related with pornographic offences, capturing pornography, transmission of pornographic content, vulgarity, all are covered under section 67. 67A is continuity of those particular act, like videos or MMS are circulated. That is what is continuous pornographic act if circulated through technology. Section 67A is applicable. 67B revolves around becomes punishable offense under section 67B, and 67C revolves around intermediary offenses. As I explained previously, what is intermediary? These are all service providers or facilitators of all communication related services, and they are mandated to follow certain guidelines. If they deviate or violate certain guidelines, then they can be acted upon or action can be taken against them under provisions of section 67C. Most of the provisions under Information Technology Act are bailable except 66F, 67B and 67A, because the punishment exceeds 5 years, 3 years. All offenses which are punishable up to 3 years are bailable, cognizable, but bailable. So the broad gist of section or Information Technology Act is except section 66F, 67A and 67B, all offences are bailable, cognizable, triable by JMFC. So next provision is offences can be investigated only by the officer above the rank of police inspector. That is inherent provision. In 2000 Act, you will find that particular power to investigate offences was delegated to Deputy Superintendent of Police. But now it is delegated after 2008 subsequent amendment to Inspector, Police Inspector. It is proposed to redelegate this particular power to officers below inspector also. But this is current legal provision that offences can be investigated by PI and above officers only. Then, as I told, all offences are bailable. Offences against women are not compoundable, but under 482, enormous powers are there. Most of the offences can be compounded. Then there is a provision that these provisions of Information Technology Act has overriding effect. So when there is a conflict of two acts, always Information Technology Act will prevail. That is in a gist what is Information Technology Act is all about in this small span of time. So now it's time for you to have any queries, because still we have 10 to 15 minutes left. If you want to have specific queries again regarding any of the provisions of this particular act, you are free to ask your questions or whatever questions you have, because if we go on cyber crimes and etc., we will not have that particular time. So anyone having any questions, please ask those particular questions. Yes, anyone, any question, please? Okay, there are enormous cyber crimes which are happening, like online medium. You must read NCRB data, that is National Crime Reporting Bureau. There you will
That's
find
social media
specific
getting to
provisions about cyber crimes.
Nagpur.
What are the categories of crime?
मैं
We,
बता
in
नहीं
our
सकता
understanding, have different
CIA के कुछ
ideas
पूछ
about
लिया कुछ
cyber crime.
कैसे
Broadly, we must understand any illegal activity done with use of technology
कुछ
is a
आंसर
criminal
नहीं
act
होता है
because basically,
क्या करना नहीं याद है
even if
भाई
your photograph is published on some social media without your permission and it offends you, you can take action. Take down notices can be sent, and with emerging or there will be huge potential for the people who understand technology related act because there are provisions of
टॉर
consent
चालू करना पड़ता है उसके बिना
unless
होगा ही नहीं बिना
we
टॉर चालू के भी
as
होता
a
है
user give our consent for that particular data circulation. No service provider can use or in bracket misuse that particular data. So this is the aspect of digital personal data protection act where understanding of information technology act will be very crucial or most emerging domain of litigation in coming days. Already the field is looking for good practitioners where nobody is trying to enter into this particular litigation area. I am again advising all of you to think this particular area of Information Technology Act or Techno Legal Act as a emerging domain to practice. Still, questions from you. If you are not able to ask question, text your question. I must understand what I am trying to deliver, whether it is reaching to you, whether it is making desired impact or not. Yes, ma'am. Please go ahead.
Hello, sir. Am I audible?
Yes, yes.
Sir,
Please
as
go
a
ahead.
first year law student, what would you suggest so that we can proceed with the cyber law career, sir? As a first
That
year student, sir.
so
Thank you.
first thing is complete your degree, acquire a sonnet, and try to follow whatever is happening in Information Technology Act. Recently, Supreme Court has taken suo motu cognizance of digital arrest matter, whether that falls within the domain of Information Technology Act, where technology is used to inflict huge losses on individual. You just open any newspaper and find out how many offenses related with technology are reported on daily basis. So what is the quantity or quantum of money lost by the people with technology related act? So the awareness, understanding of law, and educating people, masses, for this particular law is the essence. Because if we know that technology, what we get through technology is always genuine, it is not so. People receiving calls from, say, service provider, those calls are paid, they share their information. So these are small tips which need to be imparted. So you can start with awareness, understanding. First is understanding of law, then creating awareness of particular activities and promote awareness campaigns to the people so that people are aware how new modus operandi are happening and just follow the law where you will understand how new modus operandis are used. And then there will be huge number of victims who will get affected. need your guidance, your advice to recover their money. So, lot of activities are awaiting since you are first year student. First complete 3 years, get the degree, and then enter into this particular profession. Anyone else? Any question?
Yes, sir, I have a question.
Yes, sir.
Yes, go ahead, please.
Hello.
So my question is,
Sir,
am I audible to
hello.
you, sir?
Yes, yes, yes. Go ahead, please. Yes, Shri.
My
Go ahead.
question is how we can protect if our password or if we mistakenly click on the fake link.
Now there are provisions if mist or say these things happen. RBI has published zero liability circular. If you report to your bank within 3 days, then that money can be reverted. So if any illegal transaction happens, the first thing is immediately reporting to your bankers who will be able to stop that particular transaction. Second is 1930 mechanism or to report nearest cybercrime police station. Now this 193 mechanism is devised where all the bank service providers are connected, and if you report that particular matter to 1930, they immediately take action, they block the account. So even if you mistakenly click the link, even if you have shared the OTPs, now Supreme Court judgments are there through which money can be recovered. So don't think that if some illegal activity happened with you and by some mistake if you have lost, even we are trying to fight and gain the money for people who have voluntarily shared their passwords, because under coercion what is happening in digital are a scam. People are voluntarily transferring the money. So if understanding of contract is, if contract is carried out under coercion, it is voidable contract, void contract. So same logic can be applied. So always believe that if something wrong has happened, there are some remedies available under law. So you can go through that particular remedy. So even if you have mistakenly clicked certain link, you are I am sure that you can recover that particular amount.
ये खत्म हो गया
Yes, next question.
Thank you so much,
खत्म हो
sir.
गया
Yes, Advocate Mandlik has
Hello.
some question.
Hello, sir.
Yes,
Sir, can I? Sir, I would
yes,
like
yes,
to
yes.
add
Anu,
2 points on the previous question that some lady has asked about the if someone is unknowingly click the link, then there is a provision that the bankers are nowadays, if the amount is very significant in nature, then they are calling to reaffirm that or confirm that this amount is due or not.
okay, okay. Yes,
And my observation is that the number of cases of cybercrime is increased in last 3 4 years. And what I've observed from the recent years is that our cases are much more, and that too pertaining to the Pune region. I have observed most of the high tech people are getting duped by this kind of illegal mindset people and elderly people. So what the government is doing about it, and I think that the government is losing so much of time and money of the people of India, because the
okay.
information is
Anu,
already being
you can
collected.
stop here. There are few questions. These are your observations, valid observations. Yes, if you have any question, because we have limited time. If any question is
Okay.
there, anyone can ask, or I can take it as a last question. Yes, what is the future of digital signature in law for filing online? Now, there will be new modifications because digital signature is not free of cost. So that is the hindrance. Unless the signatures are provided free of cost, then only people will use it. There is a future of digital signature. It's not that digital signatures are not properly required, but since those are coming with some price, if somebody is asked to pay say 1,000 rupees, 500 rupees for signing some document, why he will use that particular, and it cannot be compelled for everyone to use that particular signature. But future of digital signature is bright. It's not that it's obsolete activity, it's good, future is good. Yes, I will take last question and then we will conclude. If anyone has any question, coordinator can ask that particular question or we conclude. I thank organizers for giving me this particular opportunity, both the coordinating professors and Dr. Moore, principal of now what is law school now. I think it is renamed as law school. I am not used. I am used to talk about main branch Ambedkar law. But I thank everyone who has taken pains and efforts to organize this particular seminar, and hope most of you join this particular profession as a cyber law consultant or expert.
Good morning, sir, and everyone present here. Um, on behalf of our institute, we extend our heartfelt gratitude to Sir Dr. Mahendra Limaye, sir, for giving us insightful knowledge about the topic on cyber law, and we truly appreciate your time and efforts you dedicated for this topic, and thank you for clearing all the doubts of students. Thank you so much, sir.